Thanks. I have a place here where I can grab my notes, so I don't want to make this too formal. And please stop me at any point. I don't want it to be just a lecture. Just stop me at any point. If you have a question, something you're curious about, want to know about, just stop me and we'll go through it. I'd love to answer questions. My background, the one thing most relevant probably to copyright law was the course I taught at SU for 10 years, music industry law and ethics, which Joe was part of hiring me for. A course I love doing, and that covered a lot of copyright law. Let me get up here. I gave you a handout that has a lot of stuff that I think is helpful that you can check on your own. I give the website address for the Copyright Office and one part of that website that's particularly related to the performing arts. And I think that has tremendous resources on there. If you experiment and get around that website a little bit, you can find the answer to almost any question you have. It also has links to the full copyright law, which is long. It's an entire volume in the US Code, and very complex. You almost need assistance reading through that, let alone the regulations which the Copyright Office passed underneath the copyright law. Those are even more complex. So sometimes you need help in figuring out how does this really work. They have a lot of videos and things on the copyright website that explains things in very simple terms. Let me just start at the beginning though. I'll give you a little bit of the academic background. Copyright's a form of intellectual property. Now in law, property is a huge subject, but there are basically two types of property. Real property, which is land and things attached to it, and personal property. In personal property, there are two types: tangible personal property and intangible personal property. Tangible relates to physical objects, things that you own, your car, your furniture, everything that you own is personal property. Intangible personal property are things like a bank account, which involve certain rights. You have a right to collect your money from the bank. Your money's not sitting in a little cubbyhole at the bank. You have the right to collect the money from the bank, which is intangible. Copyright falls into that category. It's something you've created. All of intellectual property deals with creative work. Now, the Constitution, which is the source of all legal authority in the United States, traces itself back to the Constitution. If you can't find it in the Constitution, it probably isn't good law, or some provision under which it's passed. If Congress passes a law, it's got to fall under Article 1 somewhere. If it doesn't, it's not constitutional for them to do it. The federal government, hard to believe these days, but is a government of limited power. The Constitution had a provision allowing, in Article 1, relating to Congress's power, they had the power to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Congress never responded to that for almost 100 years. Doesn't mean there was no copyright as such, because there were what are called common law rights. That's an entire lecture of its own, what common law is. But common law is a form of law that was very real and very powerful that in this part of the country came from our heritage in England. Common law developed 15th, 16th century, and was a set of legal principles that courts tended to follow. And to look up the law, you couldn't just look up a statute book. Like in New York, the statutes passed by the state legislature. You couldn't look that up. You had to research cases. So common law is very complicated. A lot of those common law principles are carried over into American law under the due process clauses of the Constitution. There are two due process clauses in the Constitution, and it says that no person may be deprived of life, liberty, or property without due process of law. Now that includes an awful lot of stuff, and it includes all of the common law. In other words, the government was subject to the common law principles. The government also has the power to override those common law principles. In the case of copyright law, they never did that. So it came as a shock to people in New York State to find out about 20 years ago that common law copyright still exists. That if you write something, you own the rights to it. If you record something, you own the rights to it. That came about with Naxos Company. Everybody familiar with Naxos, the record company? And they specialized to a degree at one time in historic recordings. They republished the recordings of Arthur Schnabel doing the Beethoven sonatas, which HMV had first recorded and published in the 1930s. They did an assessment, their lawyers told them that this is no longer under copyright. So Naxos can reproduce them and sell them. Well, they got sued by the successor to HMV in New York State Court. They said they still owned the common law copyright. And that went all the way up to the highest court in New York State. New York State, in its wisdom, calls our highest court the Court of Appeals, and the Supreme Court the basic trial level court, unlike every other state. But just to realize that the Court of Appeals agreed with them and said common law copyright still exists in New York State. Who knew? Which complicates the issue of copyright. No, that's the end. When it comes, theoretically, you could go into the federal courts on that because copyright's a federal law issue, but common law isn't. And if the copyright law had specifically abrogated common law, which some federal statutes do, they'll say, like in many state statutes, for example, the penal law in New York, the criminal law, says that this statute replaces the common law of criminal law. So common law principles of criminal law were gone the minute they published that. But the federal government never did that. And since they never did it, it's exclusively a state law issue. And states have increasingly these days found out that when it comes to state law issues, the United States Supreme Court can't overrule them because they're the experts on state law unless it violates the federal Constitution, which it rarely does, and that really wouldn't. Common law of copyright, because the law just simply didn't do away with it. Anyways, I don't want to get too far afield in the academic side of it. I printed out for myself a number of the important aspects of copyright law, but let me jump to where your notes begin. And then I'll come back to that, go into a little more detail on what it says. The single most important thing to understand about copyright law is that the copyright exists from the moment you create something in tangible form. You're not legally required to file for copyright in order to own the copyright in it. Filing for copyright merely helps you to prove that at this date, I owned this piece because I created it, and I'm claiming the copyright in it. Now, that's just a claim, but it's validated by the federal government that says on this date, this piece was in my possession. So if somebody later says, oh, I wrote that 2 years later. No, you didn't. Here's the copyright to prove it. But by the same token, you can create a piece, and if you can prove that you wrote it and you owned it, you own the copyright in it. Now, that getting into proof is an issue of disputes and stuff, which is a separate issue, but the copyright exists. That's different from patent law. In patent law, you don't own a patent in an invention you've done until the government grants it to you. You have to be granted a patent in order to be able to protect your rights. You can protect the rights to a degree under common law contract law principles and business commercial secrets kind of common law. But it's best to have it filed as a patent. Now, patents have a much shorter life. They can be renewed a couple of times, but there's a much shorter life than copyright. Right now, basically, if you file copyright on an unpublished piece, it's the life of the author plus 75 years, which is a long time. That's the longest it's ever been. And in fact, researching, if it comes to performing and you're trying to figure out, is this piece still under copyright, that's a complicated question because the length of copyright has changed in the law multiple times. Recently, 1979, I think it was, changes in the copyright law, where they made it the life of the author plus 75 years. It used to be different from that. It used to be much less. Basic principle right now is that anything published before 1929 cannot possibly be still under copyright. That's the longest, if you go back before 29. Which is why, for example, some classical publishers have taken editions from 1910 and reprinted them and sold them, like some famous classical editions, the von Bülow edition of the Beethoven sonatas, for example. That's been reprinted dozens of times because it's now what's called public domain. Public domain means something which is not covered by copyright. Usually it becomes public domain because the copyright has run out, it's expired, and usually pretty old. Other things are specifically public domain at the outset. Government publications, for example. You can copy the statute book from New York State if you want and publish it yourself if you'd like to, because it's not covered by copyright. All federal law is that way. Acts of Congress you can publish. And research studies by a government agency are not subject to copyright. The government can own a copyright. People in their wills have left copyright and patents to the federal government. They can own a copyright and enforce it, but things they create are not covered by copyright. So they're automatically public domain. And being in the public domain is good. I mean, as organists, you probably use an awful lot of music that's in the public domain to start with, so you're free to make arrangements. I mentioned here poor man's copyright, which a lot of people know about. That's a surprisingly effective thing to do. If you don't want to go through the fuss of filing for copyright on a piece you've written, mail yourself a copy and don't open it. Just keep it. Keep it with your files. Keep it with your documents you initially created. Just keep it all together. When that's opened in federal court, that provides good evidence that on this date, that you claim to have created this piece, you actually had it in your possession. That post stamp, postmark by the post office is considered good evidence in federal court. So if you don't open it, you let the federal judge open it. That's true. That's true. So if that happens, mail it to yourself again. Or take it to the post office and ask them to postmark it when they send it to you. Pay them the postage, say, just stamp that for me and I'll take it back. But that's considered good evidence. Yeah, you're right. You're right. I've seen some things like that. But just make sure there's a postmark on it that you can read the date. Now that saves you a lot of fuss. If you're writing a lot of music, you should establish your own account. You can establish your own account online with the Copyright Office. Then you can file anything you file online. There's an online form with instructions right on the copyright website. And the fee is $45 for one unpublished piece of music, for example, with one author. It's a $45 fee. If you file with paper form, it's $125. So I guess you'd say they're encouraging you to file online and do it. Keep in mind, too, it's got to be in tangible form. An improvisation, for example. You don't own a copyright in an improvisation you've done in public. If it's recorded, the recording can be copyrighted. And in fact, there are jazz musicians who don't read music, who will file an audio recording for copyright, which is possible to do, because it's in tangible form. It's on a recording. And I mean, that raises the issue if someone does a surreptitious recording of a live performance, who owns the copyright in it? Does the person who made the recording own the copyright, or is the person who did the performance? You would think the person who did the performance would own the copyright in it. I'm not sure that's really clear, because you're the one putting it in tangible form, but you didn't create the work. I suspect that would go against you in federal court, but I don't know. I don't know of a case that really covers that. On the other hand, New York has a law that prevents you from recording public performances. It's not too serious a law. It's a misdemeanor, and $250 fine, I think, if I remember right. And that's only if the venue has posted a notice outside that recording is forbidden. They have to, if the notice isn't complied with, you can still do it. I mean, I grew up in an era when live recordings in New York City, when I went to grad school in New York, live recordings were available all over the place. I knew a guy, a place called Music Masters on, I think, 47th Street, that I used to go to frequently, and I'd say, hey, what do you got for so-and-so? And he'd look around, make sure nobody was there, and say, well, how about the 67 recital at Carnegie Hall? I got a reel-to-reel of that, you know, or I've got a cassette tape of this. And they're available routinely. I don't know of anybody trying to create a copyright in that, but I suppose it's possible. I do have an LP that I actually bought at Sam Goody's of the Chopin Etudes with Vladimir Ashkenazy, and it sounds like it was recorded on a cassette player. And I think it was. It was a pirated recording from a London recital he did back in the 1960s. It's some of the greatest piano playing I've ever heard in my life. And I guess probably Ashkenazy didn't care because it caught him at a high moment, a really high moment. And it's a great recording. The sound is awful. And it sounds suspiciously like somebody with a pocket recorder in their pocket, probably, when they recorded it. Anyways, when you create a copyright, people usually aren't aware of what your rights are exactly. And the statute defines them. It says the statute provides a specific set of exclusive rights, which means only you have the right to do these things. You have the right to reproduce the piece in copies or recordings. So only you have the right to make a copy. If you download some rock band off the internet from a site that isn't licensed, you've violated copyright by making a copy. And the federal courts have uniformly agreed that a copy on the computer is just like taking it to a Xerox machine or taking it to a recorder and making another audio recording. It's an unauthorized copy that violates copyright law. A number of years ago, that was a big issue with college kids downloading thousands of songs. And it was like a tsunami coming in and trying to, the record companies trying to alleviate that with a teaspoon because it was just endless. On the other hand, if you got caught, it was not a pretty picture. I had several students in that class at SU who had gotten letters. And they asked me, I can't give you legal advice, but I'd suggest you get back to them and settle with them. Where they had tracked them down and they had decided they had downloaded unauthorized, violation of copyright, all these people that had done recordings for them or with them, and they gave them a choice. They said, we can prove that you violated copyright, and the federal fine for that is, and $500 a piece, and if you've downloaded 1,000 copies, and it can go up to as high as $10,000 per violation, depending on what the federal judge thinks. And they suggested you settle with us for $1,200. Send us a check for $1,200, we'll give you a release, and you promise never to do it again, or we'll do this again. And I suggested they find a way to pay the $1,200. There are a couple famous examples where people didn't, and they thought they could fight it, went into federal court, fought tooth and nail, and lost big, and now have multi-million-dollar judgments against them. And a multi-million-dollar judgment sitting is not exactly great for your credit history. And if you ever win the lottery, they'll get it back. They did that as a matter of principle. I mean, basically, lawyers don't file lawsuits if you don't think you're going to be able to collect. If a person has no collectible assets, it's a waste of resources to bother suing them. But in some cases, they do it just to make a point. And if you ever win the lottery, we're going to collect. Otherwise, you're just going to have crummy credit for the next however many years. What's it, 7 years, I think it stays on your credit report now. And if you file for bankruptcy, it was an intentional act, you probably won't be able to erase it in bankruptcy. So it's not a good thing to do, anyways, to violate copyright, especially on an electronic medium where they can catch you. Not that that changes the rightness or wrongness of it, but it's just an impractical kind of thing. Anyways, you have the right to reproduce the piece in copies or recordings, the right to produce derivative works. That means an arrangement. You can't arrange a copyrighted piece without permission. Now, of course, that's the whole idea. They want to get money for the permission. So you seek permission. If you want to copy someone's copyrighted work, just ask them, what's your royalty fee? and you'll find out. And you have the right to distribute to the public copies or recordings of the music by sale, rental, lease, or lending. You can do it any way you want. The copyright owner basically controls the piece. And here's the surprising one: to perform the piece in public. You can't perform a copyrighted piece in public without a royalty being paid, at least legally. Now, that raises a lot of issues because every rock band in the world goes out and plays other people's stuff, for the most part. And how do you suppose that's handled? You think nobody gets paid for that? Yeah, either the band, now technically, the band is liable for it, but if they're playing at a venue, it's typical in the law. They're going to go after the deep pockets. Who has the money to pay us something? Yeah, and it's the venue, the place where you're playing. If they appear at the Civic Center has an ASCAP and BMI licenses, so that you're covered by that. Anything they do at that venue that's covered by copyright, you're covered. The royalties have been paid. That's something, experienced bands and their lawyers know, that you verify that they've got an existing license. Otherwise, you'll be on the hook for the royalties. I remember before I went to law school, I played a debut recital in New York City. And about a month after the recital, I got a letter from Broadcast Music Incorporated, which at the time I'd never heard of before. And it said, according to a recent review in the New York Times, on February 6, 1976, you played a piece called Fantasia Variations by Ben Weber, one of our licensees. You owe us $28. Please remit. I thought, what's this? I had no idea. Never been to law school. I was not experienced in music business, really. So I went to the guy who, at the time I knew, who knew the most, Phil Klein, who taught at OCC and had been doing gigs for 1,000 years. I said, Phil, what's this? He says, you owe $28. I said, I do? He said, yeah. It's a copyrighted piece, isn't it? And evidently Ben Weber belongs to a BMI. I said, and what if I don't pay it? He said, they will sue you. I said, for $28? He said, yes. They have an army of lawyers who do nothing but sue on obvious copyright violations. It'll never even get close to a trial, and you will pay their attorney's fees. And intellectual property lawyers in New York City at the time, in the 1970s, were making $500 to $1,000 an hour. If they had to fly up to Syracuse for 2 or 3 days to get an injunction, you're going to pay through the nose. You're going to pay a lot more than $28. I didn't figure that out until later, but I paid my $28. But it came as a surprise. Yeah. No, it was. I had a contract with Carnegie Hall to perform, and it was independent. I had a rental contract with them. No, surprisingly, unlike Syracuse, you don't have to hire 3 union musicians to clear the stage for you. But here's the hall. When I got there, the lights were off. You had to turn on the lights yourself. You had to clean off the stage. My wife manned the box office. You had the venue. So that's a good question. Because places that were hired, if they had hired me to do it, then I'd have been covered by their license, but I was covered by nothing. I didn't think through it at the time because I didn't know. I had no idea. And I was doing a contemporary piece that was under copyright. And I'd spoken with the composer on the phone. He never mentioned it because I'm sure he didn't think that way. He was very nice on the phone. He was too ill to come to the concert, but was thrilled when it was referred to by the Raymond Erickson in the New York Times as an excellent piece. But anyways, you'll live and learn. It's important to know, though, the right of public performance is one of the copyright owner's rights. Or to perform a recording of the work public by means of digital audio transmission. So if it's put on streaming on the internet, you can control that also. Now there's some exceptions to those rights. One is performance or public display of a legally obtained copy in face-to-face educational activities. So if you perform a classical recording for a music class, that's exempt, as long as it's a regular part of educational activities, and it's a legitimate copy that you bought, or that your school bought, or whatever. It's a legitimately owned copy. Also, the performance of a copyrighted piece of music, or the law says a dramatical musical work of religious nature, in the course of services at a place of worship or other place of religious assembly. So performances during a church service or worship service is exempt from copyright. That doesn't exempt you from having to purchase a legal copy of the piece. Remember the Roman Catholic Diocese of Chicago got sued back in the 80s. Their entire diocese had tens of thousands of copies of choral pieces. And they'd gotten bad legal advice at one point. They said, public performance in church services is exempt. So they copied mass copies of all these pieces and sent them around to the diocese. They paid a large settlement for that because that violates copyright. If they'd bought legitimate copies of it, no problem. Now some churches, I've seen a couple churches that will project words on the wall. That's probably not exempt, because the law says the exemption is for performance or display of a copyrighted piece of music or dramatical musical work of religious nature. It's got to be a musical work. The words alone are not that. So projecting words, even Bible verses, if you're using a copyrighted edition of the Bible. If you use the New International Version, that's still under copyright. If you use the New Revised Standard Edition, it's under copyright. It's still under copyright. So projecting words on the wall in a religious service, as strange as it seems, not that you're likely to get sued for that, not that you're likely to have a problem with that, but just so you realize it technically violates copyright law. Yeah? The license should cover that. Yes, if you have a like some churches do that just to cover themselves, will have a standard license, which I'm going to talk about separately here. They have a standard license to cover anything that might violate copyright, and they'd be covered by that if they pay an annual fee. The licensing, in fact, the ASCAP, BMI, and CSAC, mainly ASCAP and BMI are the ones you deal with in the United States, routinely arrange licenses with any venue that does public performances. Bars that have bands 3 nights a week, they're paying an ASCAP fee. In fact, I remember, before I went to law school, when Armory Square was starting to get developed. I came to Syracuse in '75, and shortly after that, they started to develop Armory Square into a nightlife haven. I remember there was a guy who opened a bar down there and had advertised music 4 nights a week. Well, he got approached by a representative of ASCAP who said, let's talk license. And the guy said, what are you talking about? And he says, well, you have live music 4 nights a week, and you need an ASCAP license. And he went through the range of fees. He said, well, my estimate is you have this number in attendance on average, and it's 4 nights a week for 3 hours a night. This is the fee. It was like $1,200 for the year. And he kicked him out. He thought he was being held up. Very simple. Guy went back the next night with a tape recorder, recorded about an hour of music. In the meantime, he had called their lawyer in New York. The lawyer who was going to handle it flew up. Next morning, got an injunction in federal court. That afternoon, they had federal marshals closing down his establishment until he complied. Federal marshals, with guns and all of that, they're there closed till further notice by order of the U.S. Federal District Court in Northern District of New York. And then he got legal advice. And the lawyer said, let's talk license. And the guy said, fine, after you will pay our attorney's fees and court filing costs, which added up to $15,000 to $20,000 by that point, because the lawyer had flown up here, stayed overnight at Hotel Syracuse, Went to federal court, had to go to the county clerk's office first to research the business, to get the details from their doing business certificate. Filed in federal court for an immediate, and you can get an immediate injunction for something like that. They got an injunction and an enforcement order, federal marshals there, just like that. And then the guy learned a hard lesson. Get legal advice when you start a business. And if somebody comes to you, don't just blow them off. Talk about it. And from what I understand, they paid their ASCAP fee religiously after that. Yeah.
We have a Catholic parish in the diocese that just received a letter from the United States Catholic Bishops' Conference that they are violating copyright laws because they project the scripture readings for Sunday Mass. They have two great big, jumbo around screens, and the Bishops' Conference said that it's not covered under one license, which is a licensing agency, and that they do not want the scriptures projected on screens in churches.
Yeah, I can understand that, and probably it isn't covered, but the license probably covers music, just to be sure. Just to be sure they never run into a problem with it, but it wouldn't cover that. And if they're using the standard Catholic translation, the American Catholic Bible? Yeah, and that's under copyright. Of course, I think isn't it the Bishops' Conference that owns the copyright? I don't know. So they're not likely to sue them for a copyright violation. But in general, I think it's not a good idea for churches to do that, just generally. It's asking for, I understand why, but a lot of Protestant churches do that with praise hymns. They just project one right after the other, and it's probably not a good idea. It makes it simple for the congregation, I understand, and may save them, purchasing all the music for people to look at and to sing with. And some Protestant churches, when I grew up in, we sang in 4 parts all the time. I just grew up with that. But then it probably isn't a good idea. Anyways, those are the basic rights you own in a copyright, and the couple of very important exceptions, the educational exception and the religious exemption. Now, there's also a thing called a work for hire. In a work for hire, the person who writes the piece doesn't own it. The person who hired them owns it. It's not that simple, however. And in fact, a lot of people misunderstand that because you really read the statute. If you are an employee, you're covered. If you're employed to write music for your employer owns the copyright from the minute you write it. That's a work for hire, as long as you have a written agreement that says so, that says anything you write is a work for hire, we own the copyright. It's just like patents developed on the job. Many companies have a company policy that they'll share the rights with an employee. My brother-in-law has several IBM patents, for example, when he worked at IBM. But it's shared with IBM, and he said you get a tiny share of the royalties from the patent. But they don't have to. In other words, they own anything that's created in the course of employment. Higher ed is a little more complicated because you have professors writing works related to the teaching they're doing, and to the degree it's written on the job or off the job, that's generally been considered an exception, but that's not in the statute. And it's very skimpy case law on that issue, although most federal judges recognize it as an exemption. In the Second Circuit here, they do recognize it as an exemption from your employer owning it. The other part of, let me look at the statute here, work for hire, which many record companies use to own the copyright in works that rock bands do or anybody does with them. But the statute says a work made for hire is, and there are 2 parts to it. The first part says a work prepared by an employee within the scope of his or her employment, or, here it gives a list of possibilities, a work specifically ordered or commissioned for use as a contribution to a collective work. That could be construed as a record album. Maybe. I don't know if it has been. As a part of a motion picture or other audiovisual work, as a translation, as a supplementary work, as a compilation, as an instructional text, as a test, as answer material for a test, or as an atlas. If those are the exceptions, those are the things covered by work for hire. Or if the parties expressly agree in a written instrument signed by them that the work shall be considered a work made for hire. So outside of the employment situation, it's merely works that fall into one of those categories. I think I could make a good argument in federal court that recording doesn't fall into that, and that many performers who have been told by their record company, well, we own the copyright in your recording, might actually have a case and say, this is not a work made for hire. Even if the contract says so, it doesn't fit what the statute says as a work for hire, which means they created it, so they probably own it. And I don't know of any litigation on that issue, and I'm surprised at that, because there are a lot of performers who have been locked into airtight agreements with record companies that they'd like to get out of because they don't own the rights to any of the work they've done, even if they wrote the pieces themselves. And I mean, as a lawyer, basically, I always go back and look at the statute. If I'm going to court on any issue, I want to know what the statute, if there's a statute that applies, I want to know every detail, and I have that right with me when I'm in court, because I want to be able to cite, well, the statute says this, Your Honor. I can remember a case that surprised the judge and the DA involved. Not even related to music, but in just reading the statute made a difference. For example, it says that using a cell phone while driving, while operating a motor vehicle, is a violation of the motor vehicle law. It's like a speeding ticket. It was a fairly serious one, but I once had a client who was sitting at a traffic light, and there was a Syracuse police officer at the opposite light, and she was on her cell phone. And she said, as soon as I went through the light, as soon as the light changed, I put the phone down. They stopped me and gave me a ticket for operating, using a cell phone while I was operating the motor vehicle. And then, so I took the ticket to a friend of the DA's office, and I said, how about we dismiss this? Why? I said, because it doesn't comply with the statute. So what do you mean, the statute? I said, read the statute. It says, while in motion. He said that you are operating a motor vehicle just sitting in it. People have been arrested for DWI, sitting in their car. Because under the state law, the statute says that being in your vehicle and licensed to drive it and in the driver's seat, you are operating a motor vehicle as long as you're not in the private place. If you're sitting by the side of the road, that's operating a motor vehicle. And I pointed out to the senior DA involved, I said, it doesn't say that. It says operating a motor vehicle in motion. The words of the statute matter because they define what the law is. So sometimes in copyright law, especially going back, what does the statute say precisely? As a matter of fact, it's difficult. That's why it's easy to look up a New York statute on the internet. Just Google New York statutes. You'll have a choice of 3 versions, but they're all the same text. It's easy to just read through the law and say, oh, it means this. Maybe. You've got to look at every single word and read it very, very, very carefully. Commas are there for a reason. Periods are there for a reason. And does this exception at the end apply to all of it or just a part of it? Those are serious questions that really take some, I think, background in the law to understand how to interpret them. Judges are astute at this, generally, because they have to be, because that's what they do. But reading the statute is hard. Reading the copyright law is just like any statute. It's very dense, and every word has to be parsed and thought about. And sometimes you get surprised by a word that has a special legal meaning that you're not aware of until you read the cases that interpret it. You read the cases that interpret it, and it says, well, in this context, this word means precisely this, nothing more and less. because the judge looked at the legislative record when they passed the law, and that's what the clear intent was. So the judge is going to interpret it that way, and then the case law, that case will get published because that becomes part of what the law is. So sometimes just reading the statute isn't enough. You've got to know how the courts interpreted this statute, because that puts it. Yes, it was. Right, and I didn't have to go to the judge. He agreed with me and recommended dismissal. Just send that to the judge and they dismiss it. But reading the statute, man, every single case, when I go to court, if a statute's involved, I read the statute. And believe it or not, I've known lawyers who don't, because they're used to seat of the pants lawyering, where they negotiate everything on the phone, which is 99% of legal work, to be honest, and especially in copyright law. You don't want to litigate copyright. You don't want to go to federal court on copyright. First of all, intellectual property lawyers are very expensive. In New York right now, $2,000 to $3,000 an hour for the top intellectual property lawyers. So, now on the other hand, very expensive specialists like that can get things done much more quickly than a non-specialist and a generalist. So sometimes that's a little extreme. But if you're paying $500 an hour, they may be able to get it done cheaper than somebody you're paying $300 an hour because they don't know the law as well and they're not a specialist in that area. I mean, there's some areas of law where I've gotten questions, and I always tell my client, look, go see so-and-so. They do this every day. You'll be better served by going to them. I can do this, I understand the law, but somebody who does this every day, what do I do next is an afterthought. I don't even have to think about it, or I may have to research something and figure it out. I found it strange when I graduated from law school. I'm now licensed to do things I never studied. You're licensed to do anything that doesn't require special permission. I mean, I knew people that never took anything related to family law, went out and started doing divorces. And they'd never studied the subject in law school. But the ethics rules require that any client you take on, you're guaranteeing that you will either become proficient in that area of law, you will learn it inside out, or you will associate with a lawyer who has the experience to guide you through it. And that happens frequently among lawyers. You call somebody who's a specialist, and they'll say, no, you don't need to associate with me. I'll just talk you through it. You get a problem, just give me a call, which is tremendously helpful. And lawyers do that with each other all the time. If there's something I've done frequently that some other lawyer hasn't, I'm glad to do that. Talk to them on the phone, point them in the right direction, say, no, don't do that, they'll waste time. Do this instead. And that helps, makes a big difference. And copyright law is one of those areas. Negotiation is everything. And if you get into a situation where there's a copyright violation, and most copyright violations just go by the wayside, because there's not enough money involved for anybody to bother. You're not going to get sued for a copyright violation in a small church somewhere. Who's going to pay? A church with 50 parishioners, where's the money going to come from? Maybe they've got insurance, maybe that'll cover it, maybe it won't. But you're not likely to get litigation in situations like that. But that doesn't mean you shouldn't be very careful in any case. Make sure you know what you're doing and what you're not doing. Let's see what else I've got in here. Did you want to take a break for now, or you want to keep going, or? I guess there are a few things I have in my notes that I haven't really talked about yet. What's interesting is how many different things are subject to copyright. There's a list in the copyright law of what can be a subject matter for copyright. Literary works, obviously, musical works, including any accompanying words. Interestingly, it doesn't include the title. I can theoretically write a piece called Misty and get a copyright on it, because unless the title has developed a secondary meaning. But in general, that's difficult to establish in court. So you can write a piece called Misty if you want, and that's still available in copyright. But the words themselves are subject to copyright. If you publish a song with words, the words are covered. You've got to make sure you have copyright to the words. Even when it comes to scripture, I've done a number of choral works using scriptural, for example, the prayer of St. Simeon I did that Sandy conducted a while ago. And when I use scriptural texts, I use a mixture of translations to avoid the copyright issue. If you use the King James Version, no problem. If you use a number of older standard versions, there's no problem. But for musical reasons, I didn't want to use King James, for example, for that text. So I used a combination of texts, some of them theoretically under copyright, but such a small portion that they wouldn't be subject to copyright. The general rule that many companies will use on Bible translations is that you can use excerpts from Scripture as long as it's not an entire chapter. An entire chapter would be something they consider subject. They just want to bother with less than that. So when I've used words in a piece, I'd use a mixture of translations and pick and choose the phrases that would fit the music best or that were most amenable to musical treatment when I went through it. So that I didn't use, but you've always got to be careful of that. I did a setting once of that Bob Allen did here, in fact, on Christmas Eve, a short unaccompanied anthem that used a 15th century poem. However, that poem was originally in Latin, and I was using an English translation. So theoretically, if I were going to publish that or perform it, I'd have to get permission from the translator. Because you can take, as a matter of fact, that's one other thing you've got to be aware of. A work may be in the public domain, but if somebody does a new edition of it, you can't copy that edition. Now you can compare the public domain version with the new edition, and all that's covered by the copyright is whatever was added in that edition. I've done that a couple times in my legal practice for composers who have run into an issue with old things, and the only version of it they could find was a copyrighted version. And they said, well, compare it to the recording. And anything that's you don't hear on the recording, don't use. Although that's, a little iffy. But just keep in mind, the words are covered by the copyright, yeah.
So you could have done another translation of that piece, though, right? You could have done your own translation?
I could have done my own translation if I were competent, but I'm not. And I could probably do my own French translation, but not Latin. And actually, I don't remember if that was Latin. It may have been Dutch. But anyways, I got it from a book of poetry that was copyrighted. So I asked for permission to use it, and I wasn't going to publish it, and they said, yeah, no problem. Also, some other things are good. Dramatic works, including accompanying music, can be copyrighted. Pantomimes and choreographic works, ballets can be copyrighted. Pictorial, graphic, and sculptural works, so paintings and sculptures can be. Motion pictures and other audiovisual works, sound recordings, and architectural works. Now, the interesting thing about pictorial, graphic, and sculptural works, there's a separate provision in the copyright law that there frequently a sculptor will be commissioned for like a courtyard of a building. And they'll do the work and they'll sell everything, including the copyright, to the person who commissioned them to do it. But there's a provision in the copyright law that says that if they make changes to it that changes the essential nature of it, you have the right to prevent them from doing that, up to the point of taking the copyright back. And that lasts forever. So if some building decides, this really it looks awful, we don't like it there, it's too contemporary for our company today, and we want to get rid of it, you could have a problem. You could have a legal problem. And I've seen companies that weren't aware of that. They've commissioned a sculptural or even architectural work, altering it in some way that will reflect badly. You've got to show that it reflects badly on the person who created it. But that's interesting. We don't have anything like that in music, except you can't do an arrangement, an unauthorized arrangement of copyrighted work. There's also another limitation on copyright, which is known as fair use. Fair use is a complicated area, and many people want to call something fair use that clearly isn't. I mean, if you copy an entire article and pass it out to an audience, that's not a fair use. There are 4 categories in fair use. It said the fair use of a copyrighted work, including such use by reproduction in copies or photo records, or by any other means specified by that section, for purposes such as criticism, comment, news reporting, teaching, including multiple copies for classroom use, scholarship or research is not an infringement of copyright. So if I'm doing research and I want to copy part of somebody's treatise that's copyrighted, it's traditional to ask for permission. But if it constitutes fair use, which is like a couple sentences or a paragraph out of someone's 300 or 400 or 500 page book, it's probably covered by fair use. It's not an easy thing to litigate, and it's a little more subjective than some other areas, so it's best to avoid in any case. But fair use covers that. News reporting. For example, a news report that shows some circus performer. And their dress may be covered by trademark or trade name or trade dress law. Reproducing that in the context of a news report is exempt from copyright. And those are pretty, usually news reporting is not going to run into a copyright issue because of fair use. That's such a clear exception. In writing a book and doing research, it's a little different. Scientific research, they freely quote from each other. You can't quote an entire article, but you can quote portions that are relevant to what you're saying at the time. In determining whether the use made of a work in any particular case is a fair use, the factors to be considered shall include, and it has 4 things to consider. People think, oh, I found my exception. Number 1, it's covered under that. All 4 apply in every case. You have to look at all 4 factors. 1, the purpose and character of the use, including whether such use is of a commercial nature or is for nonprofit educational purposes. If you're writing a research paper as a scientific enterprise, that's not an issue. If you're writing an article that you're being paid $1,000 for by New Yorker magazine, that's commercial. That's of commercial nature. Also, the nature of the copyrighted work, what type of thing is it? Is it a sculpture that's unique? Is it an architectural work? Is it a book? Is it an article? What is it? And how does that relate to the rest of it? The amount and substantiality of the portion used in relation to the copyrighted work as a whole. So if you're using a tiny fragment out of a 500-page book, that bends more towards fair use. But again, you have to look at all 4 of these factors and the effect of the use upon the potential market for or value of the copyrighted work. What effect is this going to have? Well, if I quote 2 lines out of a 500-page book, it's going to have 0 effect. But in every litigation involving fair use, you have to go through all 4 of those characteristics and apply them to the use. Now, that doesn't get litigated a lot simply because it's usually an afterthought. Somebody's getting sued for copyright violations. They say, oh, it's fair use. And they'll add that in as another defense, sometimes a long shot defense, sort of like the insanity defense in a criminal case.
Would you at least briefly address the issue of parody, like the Weird Al Yankovic kind of phenomenon?
Yeah, parody may be covered under free speech, which is a very powerful concept that may override copyright law, but only to an extent. For example, if you know somebody's about to publish an article that's yours, whoops, somebody's about to publish an article that's yours, you can't get a court order for them not to do it because you know it will violate copyright. You have to wait until they do it and then sue them for violation. If, however, they're doing it as a parody, again, that's a subjective matter and can be argued in court either way. Is it meant to be a parody of this particular tune? If you write some simple little dainty tune and somebody makes it sound crass, just to parody it, that's probably protected. That's probably protected under fair use and under the First Amendment, because the First Amendment can negate copyright laws. Very powerful. Free speech is a very powerful amendment. But that's a good question, because music, that happens in music. Like you said, Al Yankovic. That was a famous case, in fact. In literary terms, there are a number of those. There's a famous Penthouse case that was handled by Jerry Spence, cowboy attorney. Anybody know Jerry Spence? Jerry Spence has never lost a trial in 40, 48, or 50 years of practice. Spent 25 years as a DA, never lost a trial not once. Federal government will not go to trial against Jerry Spence. And he went to the University of Wyoming Knight Law School. You know, didn't go to Harvard or Yale or Princeton or one of the big name law schools. He went there, he's just a sharp attorney, and he knows how jurors think. He's the best there is out there at litigation. He took on a case, there was a woman who won, I think she won Miss America. And she did, her talent that she did was baton twirling. Well, Bob Guccion's Penthouse magazine did a parody of that, sexual in nature. And she was a young girl, 16 or 17, and really deeply offended. She required therapy to get past this. It was really an awful thing. And even though it didn't name her, it clearly was aimed at her. Miss Wyoming, I think it was. And Jerry Spence took the case. He won easily at trial, won easily on appeal, and the Supreme Court reversed it. Said it was clearly parodistic. It was clearly meant to be a parody, and protected by the First Amendment as a result, and that she could not collect for defamation because it was covered under the First Amendment. What's his name? Jerry Falwell also lost a case against Penthouse. They did a parody of a really disgusting parody, and he sued. Again, Jerry Spence represented him. That went all the way to the Supreme Court also, and they said it's a parody. So if you're going to do a parody musically of something that's copyrighted, make sure it's a clear parody. Because if it's just a bad version, that's a copyright violation.
Plus, it cannot be defamatory.
That's right, and it can't be defamatory. Defamation laws, again, that's an aspect of that's a limitation on free speech, actually, defamation. It's one of the few exceptions. Defamation, national security, there are a couple exceptions where the First Amendment doesn't apply. One interesting little tweak in the copyright law too, which most people don't know, Section 109, limitations on exclusive rights, the effect of transfer of a particular copy or photo record. If you buy a CD commercially, you pay for it, you can do whatever you want with it. You can't copy it, but you can sell it to somebody else. You can't perform it publicly, but you can sell it to somebody else, you can lease it to somebody else, you can do whatever you want with it. Selling it is not a violation of copyright. Now, if that provision weren't in there, you could say you don't have any right to distribute this to the public by sale, because that's an exclusive right of the copyright owner. But if you've already bought an authorized copyrighted version, a commercial version, you can do whatever you want with it. And if you sell it or give it away or whatever, that's not a violation of copyright.
That could get pretty sticky when you buy something in digital form.
When you what?
Buy something in digital form, like
Yeah.
you buy this as a
Yeah, and theoretically, making a copy on a computer to put in a file, theoretically violates copyright. Within reason. You know, if you're sending it to friends and they're all making copies of it, that's a violation of copyright. You can say, hey, I just heard this great tune online, I'm gonna send you a copy. And that's a copyright violation, because you're supposed to buy the original version. Students in my class used to always ask me, they say, yeah, but what if I only want one tune and there are 12 tunes on the album? Buy the album. Yeah, but I just want the one tune. And, and that's how Steve Jobs' new website selling single tunes made a lot of money, because those are all licensed. You can legally download those if you pay their monthly fee. Yeah, something like that.
The equivalent of arguing that you only want one movement of a suite.
Yeah, exactly. That's the thing. And if I only want one movement of a Beethoven sonata, I still got to buy a copy of the thing. That's public domain, so I can go to the Xerox machine and copy it if I want. Unless it's an edition done after 1929, in which case I cannot do that. I cannot take
And if somebody does a fresh engraving of a public domain work, then that engraving still is the fresh
the engraving can be
subject.
copyrighted. That's right. That's right, because just the way the notes are aligned and the notation is an art in itself, as the composers here know very well that the way that's done, I mean, a lot of it's done on software today. By the way, I'm curious to ask later what's going to replace Finale, but I don't know if anybody knows yet. But you're right, the way it's laid out on the page is, and the courts have ruled that the way the music is laid out on the page is an art in itself. And you can't just copy it even if it's a public domain work. So a new edition, you're going to be very careful of. A new edition may add things, even the alignment of the notes. Now, if you want to copy the notes by hand, do it out of a public domain edition, just to make sure you're not copying anything that is copyrightable. Yeah.
Kevin, what about if you go to a website like some of us organists use a website, IMSLP, which
Yeah.
is,
Yeah.
and you go there and it indicates that the English copyright is still in force, but the American edition, what about that?
That's a good question. I can't answer that question because we have international treaties. And that's a complicated question because in some cases, if you read the treaties themselves, some things like that won't apply under the treaty. But basically what applies in England and the United States, they're going to apply in both places. There may be some tweaks in English law that will not apply here, but that's a very esoteric, complex issue that you'd have to research separately because it may be covered. It may be covered by English copyright. I mean, there are international agreements, there are multiple international agreements on copyright, or if you copyright something in the United States, it's covered in Canada and 35 other countries. And they pretty much something done in England, we're going to be covered by their copyright law, by treaty. And the interesting thing about treaties, constitutionally, they trump federal law. People aren't aware of that. Federal law is trumped by a treaty. Once a treaty has been signed by the President and ratified by the Senate, it trumps federal law. If there's something inconsistent with, other than the Constitution, it can't do something that violates the Constitution, but it can do something that's contrary to federal law. I remember there was a great example of that. A guy who lived in Buffalo was working in Canada and made income in the United States, reported his income here, but the United States wanted to tax his Canadian income. The way the law worked at the time, this was back in the 80s, I believe. And they requested the Canadian government give them the IRS, the Justice Department, request that they do the litigation, criminal litigation for the IRS. They asked the Canadian government for a copy of the guy's return in Canada. They wouldn't give it to him. So they asked the State Department to make a request under a treaty we have with Canada, which allows the sharing of tax data. In other words, the IRS cannot share your tax data with anybody. That's forbidden by federal law. And Canada has a similar law. This treaty overrides both. So the IRS and the Justice Department were able to get copies of his Canadian tax return under that treaty, even though it would have been illegal under federal law. Came as a big surprise to the guy who ended up working on a plea bargain because he was, not paying tax.
Would that organization, IMSLP, would it be legal for them to be making that available?
Making it available, yes. There's a federal law that covers that now, that if you provide a platform and you're just a platform provider, you're not liable for copyright violations. If you have the right to put something on there, if somebody copies it illegally, that's on them, not you. That's the current state of the law. I forget there's an acronym for it. Never used it much just because I didn't need to, but it basically protects internet providers. It's like the Section 230 of the Communications Act that protects social media companies right now, but it's not the same thing, but it's similar. It says that if they are just providing a platform and they're doing everything legal, if someone makes illegal use of it, it's not on them. They're not liable for it. Now, IMSLP, a lot of what they have on there is public domain.
Yeah.
And it's wonderful because you can get obscure things that just aren't available. I think they took a lot from the Sibley Library at Eastman. Tons and tons of piano stuff that I thought I'd never find a copy of. You just go in there and say, oh yeah, here, just print it out. Okay? Very, very nice. But you run that risk if you get something post-1929. Was something published in 1935 still under copyright? Maybe, maybe not. As I said before, that's a very complex question. You have to research what was the law at the time it was copyrighted, and who was the author, when did they die, and that can be impossible to find. Anyways, I just wanted to say a little bit about licensing and then enforcement. Now, I did make a copy of the form. If you want me to go through that, I'll be glad to. There are instructions right with it. That's a standard PA form for a single piece of unpublished music. And you can use that. There was a time when I was practicing law where you could not use a copy of a form. You could only use an official U.S. Copyright Office form that you'd have to send for in the mail. And some composers would order 50 copies of those, but they would not accept a copied form. Now you can just print it out and download from the website. But I remember that was really frustrating for a long time. When first things I copyrighted a long time ago, you just wait 3 months to get the form in the mail, then you send it in, you wait 6 months to get the copyright document back. It's very frustrating. Now it can be done online and very quickly and simply, and you can use the paper form if you want. So, I mean, as far as copyrighting the piece goes, I don't want to say it's self-explanatory, but it is pretty straightforward. There's an instruction for every line that's pretty clear. It even distinguishes between the copyright claimant and the author of the work, because there may be a difference for work for hire, or if you've sold your rights to someone. You can always transfer a copyright simply. I hereby transfer, in return for $150, I hereby transfer the copyright in this piece too. And they can file that with the Copyright Office along with the form to copyright it. And that's very easy to do. The problem comes when somebody receives something like that and then doesn't file it with the Copyright Office. Finding a copyright holder can be sometimes impossible. And there are orphan works out there, things that are theoretically under copyright, but nobody knows who owns the copyright, or where, how to contact someone to get permission. In fact, that brings me to licensing. Basically, to copy or perform a copyrighted work, you need permission. Licenses we've talked about. There are two main organizations that do that: Broadcast Music Incorporated, BMI, and the American Society of Composers and Publishers, ASCAP. And if a composer belongs to either one of them, and they have a list of things online, you can check online to see if something's licensed by ASCAP or BMI. They can do licenses for public performance, or not for an edition or an arrangement or something like that. And you can also contact the composer directly. The composer can do that. Now, there are some cases where they have to follow statutory guidelines. For example, if you own a copyrighted piece that's never been recorded, you can negotiate what it's going to cost to record it, what the royalty fee will be. Once it's recorded, it's fair game for anybody else to record it and pay a statutory fee. That's set by statute, set by the Copyright Office. It's in part of the regulations, and that changes every 10, 15, 20 years. They'll change the rates on that. In fact, I remember when Bob Allen did a choir CD at DeWitt Community Church. And I was on the board then, so I was asked to handle the licensing for that. It was a Christmas CD. It was aimed basically at sales to the congregation at $10 a copy. And that was licensed through a group called the Harry Fox Agency. Harry Fox Agency you can go to online, and they'll license recordings up to a certain point. You can get an online license, pay by credit card, get an online license for anything that's on their list. Well, there are 13 pieces on the list, or there are 13 pieces on the CD. I checked 11 of them off on the Harry Fox list. So I was able to pay by credit card and get an online license. They gave us the right to do up to, I think it was up to 5,000. We were doing 1,000 copies and selling it for $10 each. Each tune was based on the length of the tune. If the tune was under 5 minutes, I think the fee was $75 plus a $15 processing fee. One of the composers wasn't listed there, But I was able to contact him in Tennessee. He was thrilled to bits. He says, yeah, sure, just send me $75, we're cool. And hey, send me a copy of the CD if you would. I said, sure. So we sent him a $75 check, and he sent us back he sent us the license and said, just send me a check. Very trusting. One composer we couldn't track down. I checked everywhere. Company was out of business. Composer, impossible to find him. So I said, well, include it. And if, somebody comes up and complains, we'll pay a fee. Not likely to get sued over a single fee on $1,000 copies of CDs, basically aimed at one local congregation. But we ended up going with one not licensed. And that was a calculated risk, I guess you would say. Did it violate copyright law? Theoretically, yeah. And the minister at the time had some qualms about that. Said, well, I don't know if we can do that. Yeah.
So, if that went to court, what kind of provision is there for, I tried my best to do this?
That's why I wouldn't go to court, because there'd be no point. I mean, the most they get out is $75 plus attorney's fees. If they're just suing you to get attorney's fees, the federal judges won't be happy. Because believe me, federal judges are busy. Last time I was in federal court, it was on a motion in a case where we got sued, OCC got sued by Advance News. And it took 2.5 years to get a decision on a motion. One motion in one case took 2.5 years to get a decision. It took me 75 hours writing the brief for it. I waited 2.5 years because the federal judges and magistrates in the Northern District may have 350 cases, each with the equivalent of a stack of papers like this. And when they write a decision, it can't just be yes or no. You've got to write a decision. I mean, it's detailed, precise, relating to the statute, the law behind it, the facts of the case, and what you know and don't know. It's, the decision on the summary judgment motion in that case was, the decision itself was 45 pages. And the judge had to write that, research that, and write it. So it's very time consuming. That's one point I wanted to make about enforcement. It's like most legal matters. More than 90% of legal disputes never get anywhere near being litigated. Of the ones that get sued on, probably fewer than 10% go to court. Actually end up in a trial. The only purpose of a trial legally is to determine facts. And if you go through the discovery process, you're going to have facts galore. The discovery process in litigation is very extensive. You can question everybody in sight under oath in a deposition. And you may have 500 pages of deposition testimony from one witness. And you're going to have tons of evidence. You're going to know what the facts are, and that's what impels people to settle. You don't have to go to court to establish the facts. They're already there, and most of the time it gets settled. Even cases that are sued on. Most cases are resolved by negotiation, by common sense among the parties. I remember a very distinguished professor I had in law school, Sam Donnelly. Sam Donnelly was a gem, one of the best teachers I've ever had for anything. I had commercial transactions with him, and senior seminar and business seminar. Business seminar, he told us, you're going to be representing businesses. Your first and foremost responsibility is to keep your client out of court. Keep their business running smoothly. Going to court disrupts everything. It disrupts your life. It disrupts your business. It can cost a lot of money, mainly attorney's fees, because it's going to be so intensive. If you have to do depositions, I recall settling a lawsuit. We settled for about $125,000, even though we would have won at trial. But it was a type of case you couldn't get summary judgment on, and it was going to take $400,000 to $500,000 in discovery expense. Because when you do a deposition, you've got attorneys from each side there, you're splitting the costs, and you've got a stenographer who's there, maybe sitting there for days at a large amount per hour and then charging you for the transcript. And depositions alone, you're doing 2 months of depositions, hundreds of thousands of dollars. And I know we were right on the law, but because of the factual posture of the case, there was no way you could get a summary judgment on it. Summary judgment says if the facts that are known are all in favor of the person moving for summary judgment, they're entitled to judgment. There's a standard for how you judge a summary judgment. But if you can't get the facts necessary, you have to go through the discovery process. You may be facing hundreds of thousands of dollars. That's particularly true in copyright cases. In copyright cases, if somebody says, oh, your tune's just a copy of mine, okay, how do you show that? Well, the melodies goes the same direction. Oh, yeah, right, okay, that and 8,000 other tunes. It uses the same chord progression. Okay, how rare a chord progression is it? Oh, there are about 8 gazillion uses of that chord progression. What makes yours unique that was copied? And proving that to a jury of non-musicians, good luck. I mean, it's a 50-50 proposition at best, and it's just not a place you want to be. You really don't. Litigating, did somebody copy my tune? It's the same thing with, movie scripts. Hey, I pitched a script to them years ago. They use the same basic story. Well, they may use the same basic story, but that's not copyrightable. Ideas can't be copyrighted. Matter of fact, there's a list of things that can't be copyrighted. Let me see if I can find that. I think it's under definitions. In no case does copyright protection, this is where it outlines what can be copyrighted. In no case does copyright protection for an original work of authorship extend to any idea, procedure, process, system, method of operation, concept, principle, or discovery, regardless of the form in which it is described, explained, illustrated, or embodied in such work. Right? So an idea can't be copyrighted. If you've got an idea for a story and you pitch it to some movie producer and they come out with a story a year later that's a similar story, yeah, so what? So what? It's like music. That and 8 gazillion other stories follow the same pattern. There aren't that many patterns. In fact, if you read the Old Testament, that covers 99% of dramas. I mean, 99% of drama, just the book of Genesis alone, you've got most of the basis for almost every drama that's ever existed, most of Shakespeare. The basic principles, the basic ideas, it's got to be more specific. I remember, anybody remember a tune called Rum and Coca-Cola?
Yeah, Professor Longhair or something. Professor Longhair? Rum and Coca-Cola? New Orleans thing?
Yeah, that was Maury Amsterdam.
Maury Amsterdam.
Maury Amsterdam, remember the cellist and humorist used to be on Yeah. Well, he got sued because that was a popular tune at the time, back I think it was in the 50s, Rum and Coca-Cola. He got sued by a Jamaican musician who said, that's my tune. And that actually got ready to go, that was started into trial, going to trial. And during the testimony that the plaintiff presented, they showed that Amsterdam heard his group at a resort in Bermuda. He showed with the records they got through discovery that he was at that hotel and sat through he sat through the performance. Amsterdam turned to his lawyer and said, he's right. And they ended up, he settled it for a large amount of money because he said, I probably absorbed that into my thinking, and I didn't do it. He said, I didn't do it intentionally or, purposely. But he said, now that he mentioned it, that's probably where it came from. So he said, we should settle this. It's only right. And they ended up, he paid a large settlement to the guy. And he apologized. He said, I'm sorry, when I realized I was there, I heard you, and that's where it came from. And we all know how complex music is and how things weave into your mind. And every composer knows, well, where'd that come from? You may not know where it came from. I've had that experience. I did a forehand thing with Catherine Torelli out at Castonia College once. And Jeff Welcher said to me, he says, you put Hello Dolly in there. I said, what? I said, yeah. And I said, no, I didn't. And he says, yeah, that's Hello Dolly. I said, no, it's not. A little fragment that sounds a little like that, but I don't know. Maybe somewhere in the back of your musical mind, it's there.
Memories are funny.
That's what makes copyright litigation. They're trying to get a definitive answer for something that is vague. which is why in copyright especially, very few go to trial, especially on issues like that. Did they steal my tune? And today with sampling and stuff, I mean, some generic background track for a rap album, how do you prove that that was yours? Now, I mean, some people will put electronic devices in there. I've heard of some groups that do that, rap groups that will put an electronic key in there that they can identify. So if somebody, copies it and uses it for the background of theirs, they can show that it was, and the courts have ruled it's not necessarily how audible is it. Was it literally a copyright? Did they literally copy your piece? And if you can show electronically that they did, that's a copyright violation. Doesn't matter if you can hear that similarity or not. And even if it's so, I mean, that comes very close to being so generic that you can't copyright it. I mean, I could play C, F, G, 7, C and copyright it if I want. They'll accept it, but it's so generic, there's no way you could protect it. And that's a problem, and there's a lot of music like that. It's so generic that it's almost impossible to protect from somebody writing something quite similar. And some very bad tunes are in that category that they're just so generic that you can't protect them. Yeah.
I don't know if Vince asked this before, I may have missed it, but what about digitally sampling, say, an organ?
Yeah.
Like today, they're sampling, these famous organs like
Yeah.
Salisbury Cathedral or whatever. And, could a company say, our organ, the sound of this organ is copyrighted or?
No, I don't think so. What do you think, Doug?
Or then you
Well, some of the organs, the one that he's talking about is hundreds of years old, so probably that's not copyright, or that's not.
Wouldn't be subject anyways, yeah, to copyright protection, yeah. Yeah, that's a good point.
But speaking of which, there's the phenomenon of digital processing where you can have a logarithm in your computer to process your sound to give it the reverberation of a given hall where they have
Yeah,
sampled going, through
yeah,
a frequency generator,
yeah.
getting the whole place, so you can have the sound at a given,
Yeah, given
Carnegie Hall.
venue. Yeah, exactly. There's so many facets to it that it's, most copyright lawyers really don't want to litigate something like that. Because even if you can prove your case from a legal perspective, the jury may say, it's about money, that's right. If you've written a tune that has just sold 8 million copies, that's worth litigating. And the litigation almost never gets to trial because they'll settle, because they got the money to settle. It's all about the money. It really is what it is. That's why in the case of that Christmas CD, they're not going to sue you over this. Even if the guy said, hey, you used my tune without permission. Okay, fine. How can we compensate you? Right, but there's no point in litigating that. Again, it's high volume pop tunes and high volume rock albums that are going to be litigated. And that comes up once in a while. A couple times a year, you'll read about some famous musician suing or get sued for copyright violation. And those things almost always get settled. Once you sit down and negotiate and figure out, okay, how's this argument going to play out and what's it worth? And an awful lot of litigation gets settled because it's cheaper to settle than to go to court. Even when you think you're right, like that case I mentioned, we were right, we would have won at trial. They had no case, but it's going to cost too much to litigate. So what's your price? What agreement can we reach? Now there are unethical attorneys who use that and will sue something they know is not viable and say, hey, just to even make a motion in court, it's going to take you, 60 hours of work to write the brief. So how about you pay us $10,000 and we'll leave? I've had that happen a couple times. Fortunately, when I was general counsel at OCC, I was paid a flat amount. I wasn't paid by the case. I was paid a flat amount for the year, so it didn't cost us anything for me to write the brief. It just took me a lot of time, but that's what I was paid for. Some weeks I was very, very busy. Some months, answering routine questions by phone. That's the nature of that type of job. But you have people that'll hold you up. So I all routinely said no, absolutely not. Matter of fact, there's a case still sitting on the books in Supreme Court in Onondaga County against OCC, where I said, no, I'm not gonna pay anything. You know it's a phony case. The guy said, yeah, but it's not gonna cost me anything. That case is still sitting on the docket theoretically, unless the judges have dismissed it for failure to prosecute, which after a point they will. They'll clean up their docket and say, hey, I haven't heard anything from these jokers in 2 years, so they'll just notify the attorneys and it's gone. But there are people that do that. That's unethical, absolutely unethical. And the word gets around about attorneys who do that kind of thing. Some accident lawyers will bring a case that they know is iffy, but insurance company knows their counsel is going to cost them $4,000 or $5,000 just to get it dismissed. So they'll pay them $2,500. I had a student who did that at OCC, who was in jail for a long time and had nothing to do but read law books. And sued a professor for libel. Sued a professor for libel. And I handled that myself because that's my specialty area was libel. And it's funny, we went to a motion argument on my summary judgment motion in Supreme Court. My client was with me and she was outraged. This guy came up after her and said, hey, counselor, how you doing? I said, yeah, Patrick, how are you? He said, $5,000 check from Casey Crable today, it's all over. And I said, in your dreams, Patrick. And she said, did he really mean that? I said, yeah, he meant it. What do you think he's doing this for? He makes his living with litigation. He collected $50,000 for one business by saying that the clerk called him the N-word, which he didn't, but the surveillance video didn't have any audio. And rather than have it get publicity by him suing, they paid him $50,000. Now, he wasn't a lawyer, so he's not subject to the ethical constraints, but that kind of thing. Anyways, I'm just trying to think if there's anything else that I should mention, or, there is a criminal dimension to copyright law that I should at least mention. I mean, most enforcement that we think about is civil in nature, so we're just talking about how much is owed. That's what civil cases are about. It's about collecting money, almost always. Once in a while, it's an injunction for something, or an injunction to prevent somebody from, violating copyright routinely at a bar that they're running, like that ASCAP thing I told you about. But enforcement, occasionally, if somebody is blatantly violating copyright and making money off of it, the criminal penalties are huge. They're not covered. They're not handled by private litigation. They're handled by U.S. attorneys. In other words, the federal attorney is appointed to handle criminal litigation in each federal district. We have a U.S. Attorney's Office here in the Northern District in federal court. They'll handle, again, if there's a lot of money involved, they will handle criminal litigation. Just to give you an example, let me just see. Yeah, by the way, the Copyright Office has a small claims procedure itself.
Say that again, please.
The Copyright Office has a small claims procedure of its own that they will handle if you, it's on their website that talks about it, up to $30,000. Their jurisdictional limit is $30,000. So copyright, if your claim of loss is under $30,000, it's not worth litigating because of the cost of the intellectual property attorneys. They're going to be minimum in that neighborhood just to take the case. Many large firms, if there's not at least $50,000 to $100,000 at stake, they won't even take a case because they can't afford to, because of the expenses involved in operating a large firm. But the small claims, I've never used their small claims procedure, but I know it exists and may be of use to some people in some cases. The main way to enforce it legally is a lawsuit in federal district court. Again, unwieldy. The man I used to work for, who was a litigator, said litigation is like doing neurosurgery with a chainsaw. And that's a great analogy because it can be useful when it's necessary, but boy, you don't want to get into it. And nobody, I don't care how good they are, can guarantee how a case is going to come out. There are too many moving parts in litigation. But criminal penalties, statutory damages are not less than $750 or up to $30,000 as the court considers just for each violation. And if it's a commercial thing, I remember there was a mother who whose computer was used by their son to download things, a college student, and refused to settle when they contacted her about illegal downloads. She got hit with a $13 million judgment because the judge said, you've been told this is willful. And they could have prosecuted it criminally, and she's now got a judgment, a huge judgment against her. But for a criminal penalty, it's up to $30,000 per violation. If you've got 1,000 violations, you're talking a ruinous amount of money.
So we've got about 10 more minutes, and if you have questions, we can go about 10 more minutes. So let's use the microphone for
Sure.
questions.
I've racked up a few here as we've been along, so. So, is that working now? Check, check. There we go.
There you go.
So early on, you talked about the life of the author plus 75 years. I've heard before that's the death of the author, the death date of the author.
Yes, the
Okay.
life of the author, right.
Just for
when their
clarity,
life is
yep.
ended, plus 75 years, yes, that's
Okay.
right. Yeah.
You touched on projecting copyrighted Bible verses. A lot of churches print those in a bulletin. I would assume that's an issue
So
also.
it's the same issue.
Is there a service that deals with particular Bibles and publishers for?
If you contact the publisher, they're very, I mean, from my experience, a couple of times I've dealt with Bible publishers, they're very open about, I mean, this is scripture.
Oh, sure. Yeah.
This, and they're not, and especially one small church, they're likely to, say, go ahead and we'll okay it in writing, or a small fee.
Right.
And if it's a small church, they may say, hey, send us $25, we'll send you a license for it.
Okay.
I mean, they're very good about that, in my experience. Other commercial publishers might not be, they might have a standardized larger amount that you have to pay for permissions. I know permissions in publishing are routinely not terribly expensive. Even if you think it's fair use, publishers are going to want, I have a book being looked at by a publisher right now, and they, want permissions, just permissions in writing from the company. They don't care how you get it, or what it costs.
Documentation always, right?
Yeah, they just want to see documentation that it's okay, and we don't have to make a fair use argument.
Okay. You talked also a little bit about improvisation of copyrighted work. Now, if that's getting streamed through a service, is there any infraction there? Or do you need to
No,
report on
the
the
service
original too?
usually has an agreement.
Okay.
I mean, anybody that's streaming something commercially has a license. I mean, anything you hear on TV, that's licensed.
Right.
Anything you hear at the movies, that's all licensed.
So you would report that as use of the original copyrighted material, though, like if we're using one license or
Yeah,
something like that?
that'll, I mean, usually, the streaming is covered under that license.
Okay.
I mean, usually the authors don't have to worry about this stuff, and the performers don't have to worry about this stuff. It's usually handled by the venues who are doing the streaming, or the venue where you're performing live. That's a nice thing for the performers. The performers generally, I've known some very experienced performers who really don't even think about it. Haven't even been aware that, hey, if they don't have a license, you're on the hook for it.
Well, as like music director and performer in a church, you think about all of that, so that's
Yeah.
That's
Oh,
good to
okay. Yeah.
One more question. In terms of digital music and digital files, so if I legally obtain a copy of music and I digitize that for my own use, is there any concern there?
No, again, if it's for your own use, you're not sharing it. Nobody's going to care. I mean, and there's a couple of court decisions that said basically if you're, just for convenience on your computer, if you're copying it to a file, that's not a problem.
Perfect. Thank you.
Yeah, I don't think that's an issue. Again, you have to look at the bigger commercial picture, because how much money is at stake here?
Right.
And that's where your worry is. If there's a lot of money at stake, you got a big worry, and then you really should ask a legal opinion.
You use the example of the 1, 4, 5, 7 chord progression as something where, in theory, you could register a copyright for a piece you write, but you're going to have a hard time enforcing that, or
Yeah,
or
that's
ever
right.
seeing damages if somebody likes your variation on it.
Right, yeah.
But I'd like you to clarify if my understanding is confused, because my understanding is shared by a lot of people, is that a composition, whether it's instrumental or lyrical, the only things that are clearly protected by copyright are the melody and the lyrics. A chord progression basically, unless there's something really special going on with the arrangement, something very distinctive, which could be copyrighted separately, or
Yeah,
the arrangement
yeah.
could be protected. That basically, no matter how complex a chord progression may be, my understanding is that's still not subject. So I could think of, what was that song? Well, it doesn't matter. A song with a really complex chord progression.
Some Duke
Like,
Ellington things.
what was
for
that
example.
Holy Carmike song?
Yeah, right, yeah.
That somebody basically, and my concern is not so much about a human being doing this, but especially as AI is evolving,
Yeah.
that somebody could take that song,
Yeah,
take that chord progression,
yeah,
change the melody in a substantial way, so the melody
Yeah.
is different,
right.
and you even use AI generated or originally written lyrics, and basically the song is going to sound the same to a large extent. The melody is going to be different, the lyrics are
Yeah.
going to be different, and that's going to be allowed according to
Well,
copyright legislation or copyright judgments, case law so far.
Yeah, that's a good question, but what you're pointing out really is the distinction between the letter of the law and pragmatic reality. Because theoretically, everything is included in the copyright, including the harmonies. The problem is protecting it and showing that it's more than just something generic and that it's specifically copying that. But you're right, it becomes very vague. It's not there's not covered, because theoretically it is, but realistically, what's somebody going to do about it or prove, especially if the tune is different? The thing that's most noticeable, especially, it's what you can convince a jury of. And you're not going to convince a jury that, like in Rum and Coca-Cola, there's an augmented sixth chord in a particular part in the melody that was really striking that came out there. And I mean, Maury Amsterdam saw the jury's ears perk up and he said, well, right in the same spot, you have the same chord. And it's a very striking chord. And that's not enough, but that together with other stuff would probably have convinced the jury if they hadn't settled it that he had violated the copyright. But that's a good point. I mean, it's very vague.
Is that is that Robert Coca-Cola?
Yeah, it sounds that. I think that's right. I don't remember something. It's I don't know. It's a very complex.
Recently, I saw an arrangement of "O Come All Ye Faithful," and it mimicked the very famous David Wilcox arrangement. And there's always this citing of this particular chord. They call it the chord.
Yeah.
And this particular arranger used that chord with the surrounding progression. And I thought to myself, that's a violation because he simply copied.
I think it's like the straw that broke the camel's back. It could be one additional thing that they'll say, you know, this is so clearly a copy of this.
Yeah.
But again, it's what you can convince a jury of. It's what it comes down to realistically.
Yeah.
The law may say, yeah, you can't do it, but unless you can prove literally copying it, like with streaming, sometimes they can. But literally copying it is a different issue. AI is going to be a big issue. It's going to be a huge issue with copyright law because they're taking stuff from everywhere. There are lawsuits from, I think, New York Times and Wall Street Journal right now against the big AI company. Yeah.
All right, we're at our conclusion. It's 12 o'clock. Our lecture today has been recorded and will be available on the Syracuse AGO website. And Kevin has graciously agreed to allow us to copy his lecture.
Yeah.
And
We have that in writing?
Yes. Yeah.
so if you do want to go back and review, it will be available once we get it posted to our website. So Kevin, thank you very
Sure.
much.
It was fun.